May it please the Court, my name is Edith Santo and I represent defendant PepsiCo Inc. Your Honor, I wish to reserve 2 minutes for rebuttal. We are here today because due to an improperly served motion for default judgment and a very unfortunate yet excusable mistake by a longtime PepsiCo secretary, PepsiCo did not make appearance to defend against plaintiff's meritless and time-barred trade secret misappropriation claim, and consequently a $1.26 billion default judgment was entered against PepsiCo. Your Honor, this case should be decided on its merits. PepsiCo's conduct was not culpable. Plaintiffs will not be prejudiced since the oversight was discovered soon after the default judgment was entered by the court. Based on the facts and the law, PepsiCo is confident that it has meritorious defenses and the outcome of the suit after a full trial will be contrary to the result achieved by the default. Defendant now moves in a timely fashion and pursuant to Federal Rules of Civil Procedure 55C and 60B1 to set aside the default judgment. Plaintiffs filed the complaint on April 28, 2009, served the complaint and summons on defendant's agent in North Carolina on June 1, 2009, who then forwarded the complaint and the summons to PepsiCo's in-house counsel's office in New York. Unfortunately, the secretary who received it was busy preparing for a board meeting and set the paperwork aside and forgot about it. Due to this human error, an unfortunate but excusable neglect, PepsiCo's in-house counsel did not answer the complaint within the allowed time frame. PepsiCo in no way intended to thwart the judicial proceedings or display a reckless disregard for the effect of its conduct on those proceedings. Your Honor, the court should vacate the default judgment for good cause because, first, the law disfavors default judgment and favors trial on the merits of the case. Second, the default judgment was the result of an excusable neglect. Third, PepsiCo's conduct was not culpable to warrant the denial of a motion for relief from default judgment. Fourth, plaintiffs will not be significantly prejudiced beyond the mere loss of the judgment, which is not sufficient. And fifth, plaintiffs did not properly serve the motion for default judgment on defendant, and plaintiff's complaint was not timely or legally sufficient because it was not filed within the 3 years of when plaintiffs knew or should have known about any alleged misappropriated trade secrets, and plaintiffs did not provide sufficient specific detail about any misappropriated trade secrets they alleged based on some meeting that took place in a pitch room 28 years ago. Plaintiffs alleged that they pitched an idea to PepsiCo in 1981. PepsiCo sat on the idea for well over a decade and then stole their idea when launching Aquafina. PepsiCo started marketing Aquafina in 1996, and Aquafina has been sold widely throughout the United States. Yet plaintiffs allegedly did not notice any similarity to their pitched idea until 2007, 13 years after Aquafina was first introduced by PepsiCo and 26 years after plaintiffs pitched their idea. Plaintiffs took another 2 years to file their lawsuit alleging trade secret misappropriation. Plaintiffs' claims are time-barred. Your Honor, for all the reasons mentioned, PepsiCo respectfully asks the court to grant its motion to vacate the default judgment. Thank you, Your Honor. I now stand for questions.